OK， 好，各位委員，我哋
Members, as we've got a quorum already, I now call to order the meeting of the panel on administration of justice and legal services. Since the last meeting, paper CB 48321415-01 has been issued to members. It's an information paper on proposed legislative amendments relating to Suitors Funds Rules provided by the Judiciary Administration. According to the Judiciary, if members want to discuss the paper with the assistance of the Judiciary, then the discussion can take place on the 22nd of June. So do we want to have a discussion on the paper? If so, then that will be on the 22nd of June. Next item on the agenda, items for discussion at the next meeting. Members, may I refer you to two papers, namely CB 4825-1415-01 list of outstanding items for discussion, and paper CB 4825-02 list of follow-up actions. On the 31st of March, Mr. Dennis Kwok wrote to me requesting that a discussion be held on the arrangements concerning legal advice given to those detained at police stations. And this item has been included on the list of outstanding items for discussion. Our next regular meeting will be held at 4:30, 18th of May. And three items have been proposed. Manpower and other support for the judiciary, proposed creation of a supernumerary directorate post in the Judiciary Administration, and review on the implementation of civil justice reform. Do members agree that we should discuss these three issues at the next meeting to be held in May? Just to remind members that concerning the first item, on the 16th of December 2013, the panel spent some time discussing the manpower situation at different tiers of our courts and the long listing time for court cases. And so concerning long listing time, shortage of manpower resources within the judiciary, and also lack of office space in our courts, these matters can be followed up at the next meeting. Correct, including the issue of court facilities and also office accommodation and under provision of courtrooms. Then next, the judiciary has proposed that a time-limited supernumerary directorate post be created to enhance administrative support in taking forward the many initiatives requiring legislative amendments. And this is in anticipation of the passage of the appropriation bill. And then review on the implementation of the CJR. In fact, this item was proposed by Mr. Dennis Kwok, and the legal profession has identified problems and deficiencies since the CJR came into operation in April 2009. Mr. Dennis Kwok. Yes, Chairman. Concerning item 3, a review on the implementation of the CJR, can I request that the Bar Association and the Law Society be invited to attend the meeting for the discussion? Yes, of course. Do you have other items that you would like to propose? Chairman, I need to go to the airport at 5:30, and so concerning review of solicitors' hourly rates, I have written to the panel, and the letter contains the questions that I have on the matter, and I hope that replies can be given by the administration. I just want to say that I need to apologize, Chairman, because I have to leave early today. Thank you. Ms. N. Chang, so you raised your hand. So I was trying to indicate that I wish to queue up to ask questions. All right. So let's invite the administration and the deputations in. Under Rule 83A of the Rules of Procedure.
Yep. Thank you. 我諗等佢哋坐定先讀呢個啦，係咪？因為佢可能大家有啲係教 PC 啊，可能佢。佢係咪有耳筒啊？有呢度我有發言稿俾你。冇啊。夾咗喺呢度。咁我哋咧就係
Would like to welcome the Bar Association, the three law schools, and also the Law Society, DOFJ, for coming to our meeting. So if necessary, you can wear or put on the earpiece, and we have simultaneous interpretation service today. You can tune into the channel that you prefer, and when you speak, please refrain from speaking in cocktail language, and please use the microphone when you speak. And today we have simultaneous interpretation service. Please tune into the channel that you prefer. Channel 0 is the floor channel, Channel 1 Cantonese, Channel 2 English. So perhaps our colleagues can give some assistance to our guests if they need simultaneous interpretation service. Can you please put on the earpiece for simultaneous interpretation, please? And please tune into the channel that you prefer. And we'll invite the deputations to speak one by one.
Just because it will talk about the time limit for your presentation, and most of our members may use Cantonese to express their views. So we welcome you and invite you to use your SI services if you could not understand the Chinese or Cantonese language. Thank you. 好啦，咁咧
All right. So I'll be inviting the deputations to speak one by one. Each deputation will have 3 minutes. 3 minutes. And when you speak, please highlight the salient points in your written submissions if there are any. And there is no need to read out the written submissions or repeat what is in the submissions. Just highlight the salient points. The panel will upload these written submissions received from deputations onto the website of the LegCo. And if you have supplementary remarks in writing, you are welcome to give us those remarks after the meeting. And I would like to remind you that neither your written nor verbal submissions will be covered by the LegCo Powers and Privileges Ordinance. I would like to also remind our members that under Rule 83A of our Rules of Procedure, if members have any direct or indirect pecuniary interest in the matters being discussed, they should, before they speak, disclose the nature of the interest. And I will also declare my interest. I teach in the CTU Law School, but then I do not teach PCLL courses. So that's my declaration. So The matter being discussed is legal education and training in Hong Kong. We've got the following papers. CB 4825-1415, bracket 03, bracket 04, bracket 05, bracket 06. And we also have paper 850, bracket 01, and bracket 02. And for some of the papers, we only have the Chinese version. For some, we only have the English version. And now I would like to invite the D and the deputations to speak one by one. So, first of all, the D. The administration has said that it would like to listen to the views of the deputations first before it responds. And so I'll now invite the Bar Association to speak, the Hong Kong Bar Association.
I'll just maybe say a few words to make clear our stance. We are present in this meeting as the government department. We play two roles. We are an employer, and at the same time we're concerned about the policy of development of legal education and training in Hong Kong. We're aware that the Standing Committee on Legal Education and Training, the chairman, Mr. Justice Chan, has issued a letter dated the 16th of April setting out the report of the salient points. And it has also covered the direction of review of legal education and training in this regard. We don't appear on behalf of the Standing Committee, however, we are one of the members, so we're very concerned about legal education and training. We're here today to listen to views from organizations and institutions so that we can play a better role in the review of this matter. After the deputations have spoken, you may also state your comments or see how we can follow this up. First of all, we will start with the Bar Association. Mr. The representative. Good afternoon. The stance of the Bar Association is very neutral. The view of the Bar Association is that we do not object to reviewing what needs there are in legal education and reform. The role of the Bar Association is a passive one. It's been many years since the last review, and we think that it is right to review it from time to time. We don't have a strong view towards the views expressed by other institutions. There was actually an examination, an entrance examination proposed by the Law Society. We have some views on this, and we have already expressed it. And from what we've seen from the submissions of other institutions and bodies, we'd like to say that the Law Society once said that if the sum involved is more than $1.5 million, the Law Society will underwrite it if other stakeholders are willing to share the sum equally. In this regard, the Bar Association has made it very clear at the outset that we are willing to contribute towards it, but it's subject to a ceiling. So if in the end say is $5 million, then the remaining $3.5 million to be shared by 5 bodies is something we do not agree with. That's something we can make very clear. So you're most concerned about resources. Let's hear from other bodies first. You have finished? Yes. Next, we have Faculty of Law of the University of Hong Kong, Professor Michael Hall.
Chairman and members of the panel, excuse me. The Law Faculty of the University of Hong Kong is very grateful that you've invited us here to be heard. We're very happy to be here. Like Mr. Edward Chan, we also welcome the Standing Committee on Legal Education and Training's coming inquiry into the entire legal education and training process. I think this can only be a good thing. And our suggestion is that any further discussion on common entrance exam or anything to do with legal education and training be informed by the results of this inquiry. The second point that we raised in the submissions is that following from the last proceedings, the faculty has taken on board some of the expressed shortcomings of the present system. And what we have done starting 2014 is to interview borderline applicants, applicants who would otherwise have just fallen below the threshold for admission. The idea is to capture them and to interview them and to look at their files more closely to see whether there is some other basis upon which we could some other basis upon which we can admit them. So we are doing this as a pilot project, and we are monitoring the progress of the students this year. And if they seem to be doing well, we will review the situation to see whether the scheme can be expanded. And the third and final point is really that we feel that there are many deserving candidates who are not government funded. So meaning there are 2-1 students, good students from Hong Kong, from elsewhere, but who, because of the limited government funded places, have to pay full fees. We think that this is unfortunate, and if money could be found to give even a few more government funded places, I think that would do a lot to help people who cannot afford it. Thank you.
Okay. 咁跟住我哋就請香港中文大。
Next is the Chinese University of Hong Kong, Dean of the Faculty of Law, Mr. Christopher Gain, please.
Thank you very much indeed, Chairman. The Faculty of Law at the Chinese University of Hong Kong welcomes this further opportunity to engage in discussion. Around legal education and training in Hong Kong. Like my colleague, Professor Hoare, we look forward to participating in the work of the Standing Committee's review of legal education and training. We are very firmly of the view that the legal education and training of the legal profession in Hong Kong should be an integrated process, and we should not attempt to unpack or unpick parts of that process singly, but to look at it holistically so that we can get the right kind of relationship between what we do in the law schools and what the professions do in terms of bringing in the next generation of lawyers. We too have been reviewing some of the issues that were raised the last time that we appeared here. We have made adjustments to some of the resource implications around admitting extra students into the PCLL, and we will certainly have all of that in place when we need to do it for the double cohort. We too are reviewing our admissions process, and although it's a little late in the day for this year, we will be putting in place changes to our admissions process next year, which we believe will help to improve access, at least for those students who have previously found access difficult, if you like, in those marginal cases. Finally, I think it's very important to say that expansion of numbers admitted into the law schools for the PCLL has a very close relationship to the question of what the career opportunities are for the young people who graduate from the law schools. And while we believe at the moment there is quite a close match between the number of graduates who appear from the law schools and the employment of young people in the legal professions broadly described in Hong Kong, I think we would require a little bit more work to be done on what the future prospects for young lawyers might be before we were confident about increasing on a continuing basis the number of PCLL graduates very significantly beyond where we are. Thank you.
Okay.
Next is the School of Law, City University of Hong Kong, Professor Lin Feng.
I would like to thank you and also the members of this panel for giving us the opportunity to express our views on legal education in Hong Kong. Given that we've made our written submissions, I just want to highlight 2 points. You can refer to essentially the paragraph 6 and 7 of our submission. The first point is really a policy decision, I think, which not the 3 law schools can make, but the whole society, including the legal profession, should make. That is, what sort of legal education we want, in particular with regard to the professional training. Whether we want to adopt a laissez-faire approach, like what's adopted in UK, or we want to adopt our current position that is a more sort of controlled approach. Okay. So that's a decision we need to make. And the second point I want to emphasize is we mentioned in paragraph 7, that's the current 2 reviews of legal education in Hong Kong. One is the CEE, the Common Entrance Exam, and the other is the comprehensive review conducted by the Standing Committee, or to be conducted by the Standing Committee on Legal Education. And I think our position is the same as that taken by the Bar and other law schools. That is, CEE is much better to be taken or considered under the comprehensive review to be conducted by the Standing Committee of Legal Education. Yeah, thank you, Chair.
好，多謝林峰教授。
Thank you, Mr. Lin. Next, we have Department of Law and Business, Hong Kong Shu Yen University. Mr. Sammy Ng. I think he's a friend of the alumni. Mr. Ng, thank you. I represent the alumni of the Department of Law and Business, Hong Kong Shu Yen University. After Shu Yen University, I obtained PCLL and Juris Doctor at the Hong Kong Chinese University. I was once a participant, and I would like to give my views, taking this opportunity to assist in the discussion. And I'd like to say that the Standing Committee will conduct a review about the current approach of legal education and training. We strongly support this review. Compared to the last time, we're talking about a number of years. That was back in 2002. It's a tiny review because this will be conducive to the future development of the legal sector in Hong Kong. We would also like the Standing Committee to conduct an in-depth study on CEE, that is the Common Entrance Examination. I told you that I was once a participant and I'm now a trainee solicitor. And I have 2 observations when it comes to the current qualifying system. There are 3 tertiary institutions providing PCLL courses. But when it comes to the entrance requirement, there is no consistency. In Hong Kong, you see a lot of graduates from law school or local ones. They wonder which law school they should go to for PCLL, because you may have very different results if you apply to A or to B. And we wonder whether it can be reflected in the number of intakes, but we find that it is not in the information is not in the public domain. So when graduates of law school would like to enroll in PCLL, they have no information for reference and they feel quite helpless. We hope that the transparency can be enhanced. And a lot of local law school graduates or overseas ones and even their parents are very concerned. Because if you use this year's result, you may not be able to get, you may not be accepted. But what about next year and the year after that? Maybe the chance is getting slimmer. Maybe this time, maybe there was a slipped up, and there may not be a chance for them to retake the subject and try and get accepted.
Next, we have the Law Students Society Executive Committee CTU of Hong Kong Student Union, Ms. Charmaine Chan.
Similarly, I'm very honored to be here to speak. I'm personally a Year 1 student, a LLB student, as well as the president of the Law Student Society at the City University of Hong Kong Students Union. Before I speak on behalf of the Law Student Society, general meetings and pollings have to be conducted, and due to some time constraints, we're unable to do that. So I cannot represent the full members of the City U Law School. But however, I have been invited, and I can express on my own behalf as a law student at City University of Hong Kong's Law School. As a law student, I see a lot of my peers, as well as myself, when we're studying law, a lot of us to be stressed when getting into PCLL because we're not sure if we could get in. And also, a lot of the goals of for us to get a law degree is to become a lawyer, personally as myself, and I see some of my peers. So I think that it'd definitely be beneficial if there were more spaces available in the PCLL. Also, I think other countries have some centralized exams, as well as some countries not allowing the first degree of the students to be a law degree, and it has to be their second degree. I think these can be referenced if the PCLL system was to be changed. So yeah, thank you. Here's just some of my opinions as a law student.
好，多謝你陳會長嚇。
Thank you very much, Ms. Chan. Next, we have the University of Hong Kong Law Alumni Association, Ms. Elaine Liu. Thank you. Members, I will be very brief. Our association welcomes the review on legal education and training. At this stage, we don't have any particular views, and we haven't identified any inadequacies that need to be addressed. But then we understand that the Law Society would like to introduce the CEE, and of course that will have implications on legal education and training in Hong Kong. Our association is concerned about the development, but at this stage, we don't have any particular views. Thank you. Thank you, Ms. Liu. Next, we have Business and Professionals Alliance for Hong Kong, Mr. Ricky Sun, Deputy Spokesman, Committee on Youth. Chairman, in fact, many were not able to get PCLL places, and they are very frustrated. And you know, the number of places is limited. Competition is extremely keen. And when young people know that they cannot get a PCLL place, they know that they won't be able to join the legal profession. And they are very frustrated and disappointed. And I think that's very unfair to them. In fact, there may not be uniform or consistent admissions standards. As far as I know, for some who can get a place, they may not necessarily perform better than those who cannot get a place. All three universities say that admission is based on merits. But then concerning the intake process, there is no monitoring by a third party. We have to address the frustration and disappointment of these students who have been turned away. Some of them paid very high fees for JD courses, over 200,000. The 3 universities have said that entry to PCLL courses is not a one-in-a-lifetime opportunity. But if you try again the following year, it doesn't mean that your chances will become bigger. And there aren't additional places available to address the growing demand for PCLL places. So for LLB or JD graduates in Hong Kong, I don't think you can expect them to get qualified overseas and then come back through the OLQE channel. So the PCLL represents a bottleneck. And so I think the idea of a CEE can be explored. The CEE exam should run parallel to the existing PCLL programs. So the CEE should not be an additional exam. It should not replace the PCLL program. So if candidates can't enter the PCLL program, then they should be given an alternative chance, and that's the CEE. Mr. Sun, thank you. Just because I didn't really want to interrupt anyone, so please refrain from speaking in cocktail language, so as not to pose too much difficulty to the interpreters. All right, so I'll now invite our members to speak and ask questions. 2 members have raised their hands. All right, 5 in total. 5 in total. Ms. Ann Chang. All right, each member will have 4 minutes. Ms. Ann Chang. Chairman, thank you. The DAB welcomes the review and a study on the feasibility of a CEE. We know that some have studied for a long time, but because of health reasons, because of family reasons, they don't get results good enough to enter PCLL courses. And as a result, they are denied access to the legal profession. In fact, many of them have aspired to become lawyers, but then because they can't get into PCLL, they can't become lawyers. So I think the idea of a CEE should be explored. It's an idea which is worth exploring. Chairman, I would like to refer to our LegCo background brief, para 48. It says that there are different stakeholders represented on the standing committee. And I want to know whether different stakeholders include those who could not get PCLL places. So what is meant by different stakeholders in para 48 of the background brief provided by the LegCo Secretariat? Do different stakeholders include those who could not get PCLL places? Yes, perhaps Mr. Wong can give us a reply. Can you tell us more about the composition of the Standing Committee on Legal Education and Training? Chairman. Well, the review will be steered by the Standing Committee. And of course, I understand that the Standing Committee will commission consultants to carry out the the review. And of course, there will be consultation, and I will certainly relay Ms. N. Chang's concern to the consultants. Now, concerning those who have completed LLB and who have difficulties getting PCLL places, how can we address this issue? I believe that will be looked at in the review. Now, because in this review, we have to take into account changes that have taken place in Hong Kong. We have to look at how our legal education and training can suit the needs of Hong Kong. So we'll reflect Ms. N. Chang's concern to the Standing Committee. Yes, Mrs. Chang, perhaps you can read paper CB 4825, bracket 03, and you can read Annex 2, and it seems that the students are not included in the list. That's paper bracket 03, 825, bracket 03, Annex 2. And you can see the composition of the Standing Committee. Mr. Dennis Kwok. Yes, Chairman, I represent the legal sector, and I want to say that I welcome the comprehensive review to be conducted by the Standing Committee. And I hope that the two professional bodies will do this. Now, as they are also represented on the Standing Committee, if any of the professional body wants to see changes to the professional examinations or qualifying examinations, I hope that they will introduce major changes only after the Standing Committee has completed the comprehensive review. Now, in fact, students now studying law are eager to know how many exams they will have to sit for, how many subjects they have to study, and so on and so forth. So they are rightly concerned. And then many deputations have talked about PCLL, and in fact, during LegCo sittings, questions were asked about PCLL courses. Every year there are 1,400 to 1,500 applications for PCLL places, but the total supply of places is only about 700. And so many people have to be disappointed. And so perhaps I can invite the three law schools, the deans of the three law schools, Hong Kong U, CU, and City U, to tell me the following. So what should be the way forward for PCLL courses? What improvements are needed? Now, many have talked about problems associated with PCLL. Many people can't get places. So can I ask the three deans what improvement measures are required? All right, who will speak first? Hong Kong U? Hong Kong U? Professor Michael Hall first?
If I understand the question correctly, I think the honourable member wants to know whether there is any capacity to increase our...
What do you think is the way forward for the PCLL? I mean, having heard all the concerns about PCLL, lack of PCLL places, quality issues, what do you think should be done?
I think this is what the Standing Committee study hopes to do, to collect enough information for us to make a sensible decision about this, whether it is to retain the present system or whether it is to increase PCLL places or to put something else inside. I think, for example, if let's say increase PCLL places, I think there are a number of issues that are engaged. One is a question of quality. Of course, the more PCLL places you have, the quality of the students that you bring in, right, will be perhaps a little less. And the other question also is what we want to do with the situation where we have people who are fully qualified but who cannot find a training contract, cannot find a job. Right? Is that situation better than the one we have now? So I think the experts are going to look into this and give us sort of the pros and cons of all these situations.
So what's the reform direction, or you have a particular view on that?
We certainly have an open view, and we will do whatever is best for Hong Kong. Yeah.
Mm-hmm. Okay. Then Chinese University, Professor Christopher Gain, please.
Thank you. Yes, I think like Professor Hall, we also have a pretty open view on how this should go forward. It is, as I said earlier on, very difficult to deal with the process of taking, let's just say, an LLB student who is a recent high school graduate and getting them to the point where they can be an entrant into one or other branches of the legal profession. That is a complex process. It requires the development of these young people over a period of time, and it requires more thought, I think, now to the relationship between what goes on in the universities and what goes on, dare I say it, in the office or as they enter into pupillage, because this ought to be an integrated process. And we can't, as university providers of the academic stages of legal education and training, give you the answers without engaging in proper dialogue with the profession, because in the end we're all involved in producing the next generation of young lawyers. So do I have concerns about the number of young people who are able to get into the PCLL? Yes. Is there an easy answer to this? I'm afraid not. There are physical constraints on the capacity, I think, of all of the law schools to take more students. It isn't possible either to simply think of putting an extra 50 students into a classroom, because that's not the way that the PCLL is intended to be delivered. The PCLL is a very hands-on program. It's skills-based, which means that it's labour-intensive in terms of the people who help to deliver it. And I'm afraid to say that it's not always easy to get those people who are appropriately qualified to provide that additional capacity. So this is a complex picture, and the Standing Committee's review provides us with, you know, not a once-in-a-generation opportunity, but probably a once-in-a-10-year opportunity to once again work with our colleagues in the profession and with other interested parties to get it right. Thank you.
Okay. City University, Professor Lin Feng, please.
Thank you. You've raised three issues here: the admissions, consistency, and quality. I think with regard to admission, there is certainly room for improvement, and with all three law schools are actually considering, particularly the differentiation between the fresh graduates and those from the past. Okay? Because we all know that great inflation is happening around the world. So if you couldn't get in the first year, then hardly any chance for you to get in the second, third year. So there is a possibility to differentiate those two groups. So maybe keep some quota for those repeated applicants. So there's room for improvement on the first issue. On the second issue about the consistency, I think in the past, we actually had one practice with Hong Kong UNS. That is in the, if I remember correctly, it's in a conveyancing course. We had a sort of common exam for the same course. So there's a possibility to explore that further, maybe just take one or two courses, those which is feasible to have the same exams. Okay. And then the third is about the quality. And so far from the feedback from both the bar and the law society, and their positions are consistent. They are quite happy with the quality of the PCL graduates. We've never heard any complaints from the two branches of the profession. But eventually, of course, it goes to the issue of quota. And I think for the quota, exactly how many extra places you want the three law schools to put there, I think it's not for us to answer. And it's essentially for the profession whether the two branches of the legal profession can absorb and how many extra they can absorb. Okay. If they can decide that, I'm pretty sure the three law schools can do something about it. Thank you.
Very short, quick response, if I may. I think we shouldn't forget that for a lot of students coming from low-income families or grassroots families, getting a law degree is a life-changing event. both socially and economically. And I think in this review process, we mustn't forget that. Thanks.
好，咁呢就跟住係阿劉慧卿議員。
Next, Ms. Emily Lau. Thank you. I thank you all for coming to the LegCo to give us your views. We've been talking about this for quite some time. And we hope that with 1.5 million from the government to take forward this study, hopefully it will bring about some changes. And I see from some universities that they are aware from Hong Kong U that there is not enough resources. They would like to get some resources to increase the number of places by 10. I understand that it's not just about increasing the number of places. Professor Gain of the Hong Kong Chinese University said at the outset that we have to look into the job prospects of lawyers. And I'd like to ask deputations, is it the case that we are going to keep training and churning out an unlimited number of lawyers? Will there be the problem of an oversupply? I'm not from your sector. Perhaps you will need to tell me, when you design courses, is it one of your considerations? Or is it the case that it doesn't matter, as long as there is resources, there is space, there are teachers, then you can keep increasing the number of places? Professor Ging, can you tell us about the point you mentioned, about the concern you raised?
Addressed to you, Professor Ging.
Thank you very much indeed for the question. The fit between the number of graduates and the market is not something that we look at when we are designing our programs, but it is something that I think it would not be very responsible of us, in fact it might not even be very ethical of us, to expand the number of students going through the PCLL in the knowledge that we were adding to their stress and their financial burdens, and yet coming out at the end with no realistic prospect of obtaining employment. I am not very convinced by the analogies that have been drawn with England and Wales, because it is well known that there is an oversupply of LPC numbers beyond the number of traineeships that the solicitors branch of the profession in England and Wales can absorb. So I think that we would be not very responsible as an institution of higher education if we generated graduates knowing with a high degree of probability that they would not be able to obtain employment in the sector for which we are specifically training them. Now, in fact, the Chinese University of Hong Kong's law faculty, and I imagine that colleagues in the other law schools will think this as well, we don't actually see our mission as simply being there to produce law graduates for admission to the legal profession. The degree in law is an excellent university degree, and it is designed to be a broad-based education, along with the general education programs and the like that are provided in our universities. It's meant to be a good university education which opens up a range of opportunities for young people, and we are very keen to promote that amongst our young people. And that is why I am not concerned very much if I see my PCL application numbers dropping, because I believe the message is getting through that there is life beyond the law degree other than the PCLL. Thank you.
So maybe the Hong Kong University, do you have similar concerns?
Yeah, Professor Hall.
Yes, I support what Professor Gain says, yeah. And I think the idea that there is no life after a failure to get into the PCLL, I think it's a little overstated. Yeah. And if you take into account the fact that in HKU, for example, yeah, we have now more double degree graduates. That means LLB plus Bachelor of Arts, LLB plus economics. Yeah. And for these students, I think the career prospects for them are quite good, yeah. Well, as good as a BA or a Bachelor of Economics, yeah. So I know that it is a big disappointment. Yeah. If you can't get it, but in fact, I had to talk to someone when I first came here about 10 months ago. I had to talk to someone who didn't have a place, and I found it so difficult to say anything here. But if you look at it objectively, yeah, I think that there are avenues out there, yeah, which are not. Which does not mean entering the legal profession as such. Yeah.
Okay. 時間你仲想
Yes. Well, perhaps we can hear from City University as well.
I think the question goes to the sort of perception of our students in Hong Kong, which is quite different from the perception of students in many other jurisdictions. If you ask the law students, I guess over 80 to 90% of them will say what they want to do is to become lawyer after graduation. But if you go to some other jurisdictions, take a small jurisdiction, New Zealand, for example, and Auckland University alone, their first-year law students is over 1,000. Victoria has over 500 first-year students. So their students, when they do the law degree, actually at least half of them never anticipated they will become lawyers after graduation. So the perception is different there. And of course, it eventually goes back to the first issue I mentioned at the very beginning, that is, what sort of policy we want to have for the legal education. Thank you.
好，咁跟住就係何俊仁。
Mr. Albert Ho. Thank you, Chairman. First of all, I'd like to say that when it comes to education of a law degree, it's not just to train lawyers. Of course, it's a very important training for lawyers. They have to have a degree in law. But there are many opportunities, career opportunities for a graduate from a law school. And for aspiring lawyers, then they have to get into PCLL of any one of the 3 law faculties. However, they have their own entrance requirement, but there is one common ground. This performance of the LLB of the graduate. For some students, maybe there was a slip-up and the student only get 2-2. But the student may be a brilliant lawyer. So unless you tell the student that there is a chance for you to start anew, otherwise, is that student supposed to just switch to another degree? There are lots of people in my law firm, they are brilliant, but they are waiting. Why can't there be another alternative, an open examination that is accredited by lawyers? A lot of people who have graduated from LLB, they've been working in law firms for 5 years. They have very good practical skills and they perform really well. Why aren't they given another opportunity? That's why I think an open exam is worth it. And as to whether there will be an oversupply, well, how many PCLL places should there be and how many lawyers should we train every year? That's a different matter. But there should be a common examination. For people who did not perform well, they can still get a second chance. I don't know whether there is a very strong reason for you to object to what I say. When you did not perform well in your degree or your exam, there will be another avenue to get a place in university without an open examination.
Yeah, maybe the professors. Yeah. You understand the question? Yeah. Professor Gain first. Yeah.
Thank you, and thank you for the comments and the question. The way in which you've expressed the alternative route, this is the first time it's actually been put to us precisely in that form. And if what we're talking about are people who have been unsuccessful in relation to initial admission to the PCLL, but who have secured employment, relevant employment, and have acquired professional experience, then I'm obviously not quite in a position to speak for my university, but speaking personally, I think that's actually quite a sensible idea to explore. You need to define the parameters and you need to define the criteria that would be appropriate for those people pursuing the alternative route. But I don't know that, I mean, I certainly would not be opposed to that. I think it's certainly something that ought to be quite constructively explored during the process of review that the Standing Committee is going to undertake. Thank you.
Okay. 時間所限.
Because of constraint of time, Professor Ho, you would like to add?
Thank you, the honourable members' views. About the case of someone who has considerable experience in practice but who just can't get a place in the PCLL. And this is precisely the kind of person we'd like to capture in our pilot scheme of admission into the PCLL. Yeah. Those who, by their grades, will not qualify, but who have strength because of their experience in a law firm. Yeah, right. This is the group that we want to interview, and to see whether we can admit them into the PCLL. Yeah.
But you have a lot of them. Without an open exam, you can hardly be able to identify who should be qualified, who are eligible. Because there will be a lot of them.
Okay.
With such experience.
好啦，何俊仁議員，係啦，我哋
All right. So, Professor Lin.
I think here is, in principle, I'm not, or our school do not oppose that, because essentially is what you're talking about is the channel, how we produce the future lawyers, just through the PCLL, the current one, or through the bar exam like in the US or China they have. So it's I think that's an issue we can further discuss. Yeah.
Okay. 好，咁跟住咧就係好
Well, I think sorry, we'll be very quick.
Yeah,
presently, there's no evidence or empirical data to suggest that the job market cannot absorb additional trainees, and I think it is up to the market forces to decide, the employers to decide whether to take on the PCL or graduates from the open course exam. And at least with the open exam, the candidates who fail to get into PCL cannot then complain that they were not given a second chance to enter the legal profession. And we agree that yes, the LLB and the JD is already a very valuable asset for a candidate, but a further step of qualifying into the legal profession would be a much more valuable asset, and it would make the candidates much more employable and open them up to better career paths. And yeah, I think in balance, the frustration of not getting a training contract is no much higher than passing everything and then failing to obtain a PCLO seat is what I think.
OK， 咁跟住咧就係阿陳鑑林議員。
多謝主席。
Next, Mr. Chen Kam Lam. Chairman, thank you. I thank the academics and the professionals for being here today. I agree that it would be a complex matter to introduce changes to the existing mechanism. At the moment, we have the 3 universities offering PCLL courses. And there aren't enough PCLL places every year to meet the demands of the students. And so I think we should try to explore the room for reforms. Now, in my view, an open common exam may not become a substitute of the PCLL courses. And I understand that a CEE may give rise to concerns, for example, professional competency and so on and so forth. Now concerning PCLL graduates of the 3 law schools, some of them may not end up being lawyers. That's my understanding. Some work in companies and some take up other jobs. And I understand that LLB graduates may not necessarily have to become lawyers. This I understand. But there are many who think that the present system is full of constraints, and as a result, there are many who are disappointed every year because they can't get PCLL places, and that's why there are calls for improvements. The Standing Committee on Legal Education and Training will be able to come up with a report only in the second half of next year. So I hope that all parties can try to work out improvements within the present mechanism. For example, can more places, PCLL places, be provided to the students? And for example, say if a student is disappointed this year, then can he try again next year? Can he be given another opportunity in the following year? So these are improvements that can be considered within the present mechanism. And I think the Law Society's proposal to conduct a CEE should be explored. In other words, those who can pass the CEE will get the professional qualifications. But of course, to make this happen, we'll have to have the 2 professional bodies and the 3 law schools working together to ensure quality. In other words, we have to make sure that the professional standards and competency of our lawyers will not be reduced with the introduction of a CEE. And we look forward to recommendations from the Standing Committee after it has completed its review. All right, I think that's a comment only. Thank you, Mr. Chung Kwok Pan. Thank you, Chairman. Many members have raised the issue associated with PCLL. I want to talk about PCLL too. Now, of course, I understand that there is a need to make sure that we'll have quality lawyers and our training programs must also be of high quality. But I think in Hong Kong, for those undergraduates who can get into law school, I think they are of high caliber. I mean, LLB holders, LLB graduates, I believe, are of high caliber, and yet many of them can't get PCLL places. That would be a waste of our manpower resources, will it not? If the law schools think that it is possible to consider allocating more resources for PCLL courses, then I really hope that we can make the best use of our manpower resources. We don't want to waste our manpower resources. And then I've read in some submissions that concerning subjects, there is one subject called Understanding of Chinese Law, but it seems that the curriculum is not in-depth enough. Now, as we all know, there are very close ties, including business ties between Hong Kong and the mainland. And so, concerning business law and also mainland law, especially in respect of business law, should we give more in-depth knowledge to our law students so that our law students will understand more about the constitution of the PRC and also mainland laws, especially business laws? Do you want the three deans to give replies? If possible, yes, Chairman.
The law schools, maybe Professor 林峰教授答先，佢講中國法律嘅課程。
Professor Lin.
And I think it's very good because here we are essentially there is a sort of balance we need to strike because Hong Kong is a common law system. Of course, we teach most courses here on the common law system, but at the same time, Hong Kong is a SAR within the PRC. So we need to. We actually, I do believe all three law schools teach students about the relationship between the Chinese Constitution and the Hong Kong Basic Law and the relationship, because the sort of connecting point is the basic law. So we do teach. In our school, for example, we have essentially one course, which is the introduction to the Chinese legal system, which is taught, is a compulsory actually for LLB students. But of course, it's only an introduction. We don't go that deep into different subjects of law in China. There is certainly room for doing that. But now what we do is we leave that essentially to after their first degree education. For example, after LLB and PCL, if they want to do more, learn more about the Chinese law, then they can do a master degree in Chinese law.
Yes, I understand that for CTU, introduction to Chinese law is compulsory. It's a compulsory subject for the students.
About the need of Chinese legal system in the legal education.
Yeah, our response is similar to CTU. Yeah. There's a compulsory introduction to Chinese law subject which every LLB student has to take. Yeah. The present thinking is that if the student wants to go more into Chinese law, yeah, we have electives, yeah, which they can choose to do, yeah, in the senior years, yeah, and also in the PCLL we have an elective in Hong Kong University called China Practice, yeah. So the philosophy now is that we give them a little bit, enough to start them off, and if they want to pursue it, yeah, if they want to pursue it, then there are electives which they can choose from to do so, yeah. And of course, we also have an LLM in Chinese law, yeah, which they can choose to do if they want to go even further, yeah.
How about Professor Gain? Yeah.
Thank you. Very similar situation in the Chinese University of Hong Kong. We do require our students to take an introduction to the legal system of the PRC, and we have a range of electives that are available in the undergraduate programme for those students who want to develop and deepen their knowledge, and indeed we'll be, in our revised degree, we have an identified Chinese law stream. We also offer China practice in the PCLL, and we have a master's degree in Chinese business law. But I think your question, the honourable member's question, is a very good one because it takes us back to the point that I made earlier. What we do in the process of legal education is not something that the universities do on their own. We are very much influenced by the requirements of the legal professions in Hong Kong, and they lay down quite a substantial number of topics that have to be covered in the law degree. And I hope that one of the things that will come out of the forthcoming review is some movement here so that we can, by dialogue, identify the things which we collectively agree are most appropriate for the future education and training of law graduates in Hong Kong. We might take the view that greater depth of knowledge and understanding of the law of mainland China is important for our graduates here, but we would have little flexibility to accommodate that on top of all the many other things that the students are already required by the professions to study.
Okay. Mr. Ng? Yeah.
Yes, Mr. Ng. Yes, I think I agree with Mr. Chong. In fact, I studied Chinese law subjects under PCLL. You know, business ties between Hong Kong and the mainland are extremely close, and such training is essential and useful. I think more systematic training should be provided in PCLL courses on Chinese law. In fact, as early as in the 1990s, Shuyan College sponsored degrees together with universities in Beijing on Chinese law. And so, for law students and practicing lawyers who need to acquire more in-depth knowledge about mainland laws, I think they should carry out further studies. Thank you. Mr. Paul Chair.
Thank you. I think to a certain degree, the number of lawyers in a place, whether there is an excessive supply, and the different path you can take are all related to the place economic development. In the past, there was an undersupply of lawyers. A lot of lawyers, after they practiced for quite some time, they went back to schools, just like our ex-secretary for Justice, Mr. Wong Yan Long. And now we have an oversupply of lawyers. It's high time to review the situation. We are awaiting the report of the Standing Committee. This is just an interim review. And I agree with what Mr. Albert Ho said. You have to balance all the factors, say quality and standard of your graduates, demand in the market, and better use of resources. That is actually the issue of justice, social justice. We need to provide opportunities for social mobility. A lot of civil servants, while they're working, they go to school and then they get themselves a law degree. For late achievers who started later than others, they have made more contributions to society or to the legal sector than those who are younger, who have gone into the legal sector straight away. If a revolving door is provided for people to enter the sector and for people in the sector to leave it, it will be beneficial to society. We need an additional path for those who found the calling maybe in their middle age. They don't have to pursue the conventional path by taking the LLB or the PCLL. This will be an appropriate and a good choice or alternative. some people criticize, or some graduates criticize the inconsistencies of the entrance requirement, the lack of transparency, and over-reliance on the result of the law degree. There should be more paths made available for Hong Kong people. And I'd like to ask the alumni of Xu Yan, would you like to have more time to finish your third point? Thank you, Mr. Zhe. Well, the first point was a lack of transparency about making the information public, and two, inconsistency in their entrance, in their intake, and third one is also about the over-reliance of the result of your law degree. And I heard from the dean of the 3 faculties that there are pilot schemes to give a second chance to people who are marginal. So how many places are there for this group? And there are a lot of graduates who fail to get a place for PCLL, or they have been studying overseas, Australia or the UK. A lot of my friends told me that they don't need sympathy. What they need is an open and fair system for them to sit for an examination again, so that they can try again. They would like to have an open examination where they can work hard towards. Instead of, say, 3 places for people who fail, for the 300 who failed last year. Without a fair system, they may choose to go to other jurisdictions, say New York or the UK, to study further, spend another 2 or 3 years, and then come back and register as an overseas lawyer. And then they sit for the Overseas Lawyers Qualification Examination of the Law Society. And then in the end, it will take them 10 years before they get a qualification to practice. It's quite common in Hong Kong. You see some overseas lawyers, maybe in the past there are only 20 people sitting for the overseas exam, and now maybe 300 a year. Where do they come from? Yes, maybe they are lawyers of international law firms, but more of them are young graduates who fail to get a place in Hong Kong PCLL, and they've chosen to study further overseas and come back. If there is a common entrance examination, or maybe more places for PCLL, well, people who fail this year, then they can sit for the exam again next year or the year after. So people who are reading law overseas or locally would like is a fair system. Mr. Alan Low. Thank you. Well, I have a lot of feelings after reading this paper. In the Redmond Roper report, I represented the Bar Association in the 2000 review. It's been over 10 years, and there needs to be another review. Chairman, as you know, in the Redmond Roper report, there has been significant changes in the education and legal sector in Hong Kong. And I heard from Mr. Chen, the Hong Kong Bar Association, that they refuse to underwrite the cost, and the DFJ will only provide 1.5 million. What if there is insufficient fund? Mr. Wong is here. He can give us more information. Well, we've been asking for experts to come to Hong Kong, but they only come from New Zealand or Australia. I remember Professor Paul Redman is from, yes, Australia. Any special reason? How come that 15 years later, we find someone from Melbourne and another from Wellington in New Zealand? Any special reasons? I would like to know. First one about underwriting the cost. Perhaps we'll hear from Mr. Wong about $1.5 million. Indeed, at this stage, the DOJ will provide support, and we have considered the budget should be sufficient to fund the study. Of course, if we find after the first stage that the scope of the study needs to be expanded, there will be further discussion at the standing committee as to what further assistance will be rendered. And your second point is about the commissioning of experts and consultants. Apart from Justice Sophia, retired judge, Miss Julian Webb actually is from the UK. Just recently, he has gone to Australia. He has done a comprehensive legal education in the UK, and that's something that we have taken into consideration. Anyone else who would like to supplement? Then it's my turn. No, but I have a question for Mr. Peter Wong. Why not say that 1.5 million is sufficient, but if it turns out to be not enough, the DOJ will put in more? Mr. Wong? All I can say at this stage is that we will actively consider it. I don't have the power or the authority to give you a clear answer. We would like to support you to seek more financial support. Yes, we will take that into account. This has been mentioned in the last meeting. Now it's my turn. First of all, I thank you all, and I see some young faces and some more deputations who have come to speak to us. This is good because we can hear from more people, especially young people. Before this meeting, I have talked to the chairman of the Law Society, Mr. Stephen Hong, said that they've been working on this, and there's a teleconference in a day or two, and they are looking into their own proposal. After they have completed the work at a certain stage, they will revert to us. I've received some comments from students. Some of them asked why legal education cannot be like, say, the medical school. There is a high threshold, but once you've got in, and every year if your results meet the requirement, then you will reach the end and practice as a doctor. But Hong Kong, and well, the number of students is not like New Zealand, but they know that the study would end after the 4th year. And some people have got second up, but they still fail to get a place in PCLL. They come from local universities and overseas universities. A lot of Hong Kong students have actually pursued their studies overseas, and they have spent a lot of money to complete their law degree. But when they come back, it seems that they don't see any future. some of them will stand outside the door of the professor's room to try to get an interview to leave a good impression, because the law faculty has discretion. How come the law faculty is different from the medical school? And I'd like to hear from the 3 faculties of law. Well, I was involved in the discussion with the starting of the JD. Well, a mixed approach of JD and PCLL. And for the US and the UK, there is an open exam along this line. Well, there may be an increase in number of intake, but the quality is better. Some people may say that, well, I read law not because I want to be lawyers, but a lot more would like to be a lawyer. And they feel aggrieved if they don't even get a chance to sit for an examination. The quality of the PCLL courses for the 3 law faculties are good. Mr. Stephen Hong said that they are very strong in their view to have the 4th alternative. Maybe if someone working as a solicitor's clerk for 10 years and still he fails to get a place for PCLL. So can you tell us, well, would that be a problem of an excessive supply? Well, you may have a bigger market in overseas market or mainland market. They may get qualification to practice. They may go out to other places or the mainland to practice.
So I'll invite the 3 law schools to respond. And then the Bar Association and others. And then finally the administration.
Like all the law schools, to just have a basic response to what I have just said on this direction, and maybe if other representatives would like to say a word, you have this last opportunities. Okay.
Because I'd like to go now. Chairman, the position is this. The reason why the bar is not really very keen on the CEE is because we think that there is a severe misconception that someone who simply passed an examination could be as ready to get into practice or pupillage or trainee solicitors as someone who has gone through a period of vigorous training such as the PCLL is now providing to the students. Normally, for an examination, you could test the book knowledge, the black letter law, or a lot of theoretical things, such as even the art of advocacy, which is very important for the bar. You could have books on advocacy that you learn by heart, but nonetheless, the first time you stand on your feet to address an audience, it will be the worst experience in your life. Now, that is the sort of thing that an ordinary CEE would not be able to provide. So that's why we have got no objection, say, for instance, if there should be sort of suggestion to the law school so that when they are considering to take on PCLL students, they would have a wider spectrum of students to choose from, such as, for instance, they could widen the scope to consider the so-called 10-year CA, spoken of by the chairman. Now, we don't have any strong views on that. But speaking from the point of view of the bar, we actually feel that those who are ready to do pupillage should receive some minimum good training, basic know-how training in the actual practice of law. And that is why we feel that the thing cannot be just replaced by a book examination, which, of course, everyone thinks, if I sit for the same examination, why am I not as good as someone who has gone through the PCLL? That is a part that I think is very often missed. Now, the second thing is about the supply and demand situation. The bar currently has got about 1,100 members, and the figures remain fairly stable. We have a small increase of, say, 10 or 20 each year, but in terms of the number of pupils joining every year, it's about 70. So there is quite a high drop-off rate in the bar, which tends to show that at least given the current economic situation in Hong Kong, the bar is fairly saturated, in the sense that I heard of complaints from the junior members that they have difficulty in getting work, and a lot of them were forced out of the profession by the cool reality of life. Now, of course, from one point of view, when one say that it is a waste just to have someone trained as an LLB student and did not get into the law. But on the other hand, of course, it could well be also said it would be even more waste if he should actually spend more time and money on the PCLL and probably a period of pupillage, and yet do not find himself to be suitable for the profession. Well, we keep an open mind on this because basically the bar lived on competition. You may feel that you are the top advocate in the world, but as soon as you stand out to practice in law, you find that you are severely inadequate, because that is by competition and comparison. So a lot of students think that they are populating God as bright as Marshall Hall, but nonetheless felt that as soon as they go into practice, it's a completely different story. It could well be said that they should nonetheless be given the opportunity, but on the other hand, of course, from another point of view, it is a case of waste of certain resources.
好，多謝陳律師嚇。咁跟住就係is there any response from the law schools? Yeah, Professor Hall, please.
Yeah, I find the chairman's reference to the medical situation interesting here, but I think the medical situation, I'm not sure that the law profession wants to go down that way, because essentially only medical degrees from Hong Kong universities are recognized here. So even if you have a degree in medicine from Harvard and Yale, you can't practice here. Yeah. So I'm not sure that that's what we want here. For many years, I lived in Singapore, which has a different way of handling this. Singapore recognizes its own Singapore law degrees and a very short list of foreign degrees here. So, for example, in UK, it used to be like 12 universities. Recently, it was shaved down to about 7 or 8 here. And so the debate in Singapore is which of these foreign law schools deserve to be on the list here. And the debate can be as emotional and heated as this. So I think what we can take away is that there is no easy solution which, I'm sorry to say, which can please everyone. Whichever solution you take, somebody will miss out. So in Singapore, if you can't get into a Singapore law school or a small list of foreign law schools, then that's the end of your ambition. And a lot of people say that is unfair, that is too narrow, anti-competitive, and so on. Right? Hong Kong has a different system. Historically, it is the PCLL admission is what I call the gatekeeper. Right? And as we have heard some of the dissatisfaction with it here, but just coming from the outside and looking at it, my preliminary view, I mean, not that of my institution, but my personal view, is that it is a system which works here, and unless there is good reason, there is good reason to show why it must be changed, then I think what has worked well enough for Hong Kong, should continue.
Okay, Professor Lee, please.
Thank you, Chairman. I too was struck by the analogy drawn between legal education and medical education. Of course, there's a very profound difference between legal education and medical education, and that is in fact why law numbers were taken out of the manpower planning arrangement some time ago. And that is, of course, that medical graduates are not exclusively but primarily employed by government. Now, I'm not entirely sure that the DOJ would be able to absorb all the law graduates that we might produce, and I would not be particularly interested in being involved in an education system which created lawyers for a single market of that kind. I think, as we said in our preface to our submission, a healthy, independent legal profession is crucial for the future of Hong Kong, and that is why I think the medical education analogy should be put to one side. I think the other thing is that it would be enormously costly to the public purse to go down those kinds of routes. So far as concerns this discussion about alternative ways to qualify, as I said earlier on, I am really quite struck by the idea of having an alternative route for those who have acquired and can demonstrate that they've acquired a certain level of professional skill and understanding, and that they want some form of certification which would admit them to practice. I have an open mind on that. I think it's something that we could constructively discuss. Everything depends on the parameters of an arrangement of that kind. But I do think that it's an idea that is certainly worth exploring. And finally, I would like to say that perhaps the most heartening part of this conversation is that while there have been questions about admissions and questions about how we make determinations of admission to the PCLL, no one has actually said that the PCLL does not serve a useful purpose. The PCLL is very important indeed in taking young graduates the next stage before they are pitched into the tremendous demands that are made on them from day one in legal practice. And it's very interesting to notice that in the United States, for example, where they do take you straight from law school through the bar examination and you go into practice, a lot of private clients in the United States are no longer prepared to pay law firms to have first and second year trainee attorneys pay them at the rates that the law firms are demanding, because they know that they're not equipped to practice in the way that someone who's gone through a more prolonged and properly designed professional training is equipped.
Okay. Professor
thank you, Chair.
Yeah.
You've raised many issues, and I'm afraid I don't really have answers to many of them. And I am sure a lot of them will be addressed by the forthcoming review to be conducted by the Standing Committee. And one particular issue, for example, the coexistence of the LLB and the JD, and whether Hong Kong should have the coexistence of two or just have one of them. I think I'm sure that will be discussed later further. Thank you.
Okay. Any other?
Any other views, Mr. Ng? Mr. Ng, please. Thank you, Chairman. I agree that PCLL is a very important course for LLB graduates. A PCLL is very important training. But I think we should seriously explore the feasibility of a CEE. There are three reasons. First, whether one can get into PCLL decides whether he can practice law. And then lack of transparency concerning admission, these are the concerns. And then, Chairman, you mentioned LLB and JD. In recent years in Hong Kong, we have had LLB, JD, CPE. I want to say that, in fact, in recent years in Hong Kong, we have had an increase in the number of law students, mainly students of self-financing law degrees, and we haven't seen an increase in PCLL places. Now, in fact, we've seen more self-financing law degree courses. I think that's because of market demand. And maybe the number of lawyers in Hong Kong should also be dictated by market forces. And so I really think we should explore the feasibility of a CEE. And then I hope that the Standing Committee can come up with very constructive recommendations for the 3 law schools and for the 2 professional bodies, and also for the various stakeholders. We hope that there can be fair and open ways for our students to acquire professional qualifications. Hong Kong aspires to become an international legal services and arbitration center, and we look forward to having very constructive reforms. Mr. Wong, thank you. I think this is really a good platform for exchange of views. We've heard very valuable suggestions from members, from the law schools, and from the deputations. I want to say that the Standing Committee will be carrying out a comprehensive review, and the Standing Committee will not just be looking at PCLL places and the possibility of introducing a CEE. In fact, the SAR government and the DOJ in particular wants to promote Hong Kong as an international legal services center and a center for dispute resolution. So admissions of students is of course very important. At the same time, we also need to look at the curriculum, the courses, room for improvement, and so on and so forth. And all these will be covered in the upcoming review. And members are concerned about resources. I want to say that we attach great importance to the development of legal education and training in Hong Kong, as can be seen by the funding support we give to the upcoming review. We will work very closely with various stakeholders to map out the way forward for legal education and training in Hong Kong. Thank you. Thank you very much, Mr. Wong. In the upcoming review, stakeholders' views should be taken on board as far as possible, and stakeholders should also include affected students and also employers. The world is changing every day, and so what does the market need? We hope that you can also take into account market demand and also the views of various stakeholders.
Well, in Annex 3, in the second point under paragraph 4, it's also touched on the Law Society's point and referred to the change in the market situation, and it should fall under the scope of the study. And this is in line with what was said. Thank you. Deputations for coming to speak to us, and I also thank the government and members for expressing concern. This is the end of this agenda item. Thank you very much.
And express your precious views to us. Okay, thank you very much. 咁我哋跟住呢就係請
Let's invite representatives of the next item. Please refer to CB bracket 4825 14 to 15 bracket 08 Judiciary Administration's paper on review of solicitors' hourly rates. Let's invite Mr. Ng Sek Hon, Deputy Judiciary Administrator, for taking us through the paper. That is the latest situation when it comes to the review of solicitors' hourly rates. Mr. Ng. Thank you for inviting me and my colleague to come to speak to you about the review of solicitors' hourly rates. I will be quick and briefly go over the paper. You'll find the detail in the paper. This involves a number of issues. In the judiciary, there are, because of the many implications, a working party has been set up to review solicitors' hourly rates. You'll find the information in the background of the paper. At the end of a trial, usually, the winning party will be awarded costs. If agreed, no taxation is required. If not, a taxing master will conduct a hearing. Usually, it's a party and party basis in the taxation. The party which has won is entitled to recover all such costs as necessary or proper for the attainment of justice or for enforcing or defending the rights of such party whose costs are being taxed. After the working party has been set up, some work has been done and a number of areas have been identified. I'm not going to go into detail, say for example the gap of the sum, attainment of justice and implications, access to justice, impact on law firms, impact on legal aid, recoverability gap, and also competitiveness of Hong Kong in dispute resolution. We would also like to make use of this review to introduce consistency and regular review, because last review was 1997, quite some time ago. So we would like to find a sustainable way to deal with this issue. The Working Party has decided to conduct its work in two phases. In the first phase, well, because of the many issues involved, they have to decide what approach is to be adopted. We have just commissioned a consultant to assist the Working Party. Work has just started. We hope that in the middle of the year, the first phase will be completed. After we have set down the direction, in the second phase, there will be implementation. Say, for example, review of the mechanism of the charge, more operations, and more the operations side. We hope to complete the second phase at the beginning or middle of next year. You'll find the details in the document. I'm happy to take questions. We have Law Society of Hong Kong, Mr. Hunsworth.
The Law Society obviously welcomes progress that's being made in this review. As has just been pointed out, it's nearly 20 years since solicitors' hourly rates were reviewed. And the Law Society also welcomes the aim and goal that there should be a procedure in the future for regular review of solicitors' hourly rates. It is important to stress one key issue. This is not a question, as it is often portrayed in the press, as to solicitors' incomes or earnings for lawyers. It is an issue as to fairness to litigants, because solicitors' hourly rates and party costs reflect the amount which a successful party in litigation can recover. The paper prepared by the Judiciary Administrator, I take issue with one point where it says that solicitors' hourly rates, if they are increased, could increase legal costs. That's not the case. In fact, as the paper readily acknowledges, the rates which solicitors charge their clients is a matter of the market. It's what's agreed between the client and the solicitor. So whether solicitor hourly rates go up or go down will have no effect whatsoever on the fees which clients will pay to solicitors. What solicitors' hourly rates are concerned with is how much the successful litigant is able to recover from the losing party. If you believe in a system, which has been the Hong Kong system throughout, that a successful litigant should be entitled to recover a significant part of his costs from the unsuccessful litigant, then the larger the gap between the actual market rate that the litigant is charged and what he's able to recover, the more unfair it is on the successful litigant. And let me just give you a small example. In a standard personal injury case, a person is injured. In 99 times out of 100, liability is eventually conceded by the employer, by the negligent motorist, behind whom, of course, stand the insurance company. If the amount which the successful litigant, the successful plaintiff, is able to recover by way of damages is, let's say, $1 million, but his legal bill is $500,000, if he's only able to recover half of that from the defendant, from the insurance company, he's left having to pay out of his own pocket, out of the damages that he has recovered, $250,000. And we are seeing this on a daily basis, that litigants, successful plaintiffs in personal injury cases are having to pay more and more out of their own pocket in order to get justice. And we believe that that is undesirable. It deters people from seeking justice, and it's long overdue that these hourly rates should be reviewed. So that is the position of the law side. But as I say, we do welcome that progress is now being made.
Okay. 跟住咧就係委員。
Next questions from members. Let me see how many members would like to ask questions. Apart from Mr. Albert Ho. Mr. Ho. The scheduled finishing time is 6:30, and I don't know whether you would like to ask supplementary questions. And I think I have to say that if necessary, the meeting will be extended by 15 minutes. Mr. Ho. I agree fully with what Mr. Hunsworth said. This review comes 10 to 20 years later. We've been using the same rate for many years now. And I'd like to know what methodology would you use to conduct this review? You mean the average rate in the profession? Can you tell me whether you will conduct a lot of surveys? Say, for example, from the expenses of law firms? We are very interested. And there is another question. When we were working on the competition ordinance, there was a strong objection towards a standard rate. So my concern is whether this will be criticized. Of course, it's necessary to do this. If one party is to pay cost, you do need this hourly rate as reference. But indeed, it was said when we were scrutinizing the competition ordinance that there should not be a proposed hourly rate. Would there be conflicts? And there is another issue that we have to face. The taxing master. The yardstick is more important than the hourly rate, because for a taxing master, questions will be asked whether you need that much time. So you will be asking questions as to how much time a solicitor should spend on this particular issue. We need more guidelines because there is wide discretion and many different yardsticks adopted by taxing masters. So would you also, in your review, look into the standards adopted by taxing masters, especially the well, the standard. Whether there will be a review to see if there's a need for clearer guidelines. Perhaps we should go back to the definition of solicitors' hourly rates. It's not for setting how much our solicitor should charge the client. In other words, the solicitors can still decide how much they charge. You have to bear in mind this differentiation. So this solicitor's hourly rate is only for reference. It's not binding. So the question raised by Mr. Ho, that is, will there be competition implications? Well, this issue is not raised in the Working Party. Mr. Ho also mentioned about the yardstick of taxing masters. They exercise discretion. It's on a case-by-case basis. I think you're talking about something completely different from the solicitor's hourly rates. Because during a taxation hearing, the master may not follow the solicitor's hourly rates.
So taxing masters do have discretion that they can exercise, and that's another matter and will not be covered in this present review. And then as to the methodology we're going to adopt, this is precisely why we need to get a consultant to help us carry out the review. You know, there can be different methodologies, say use of a model firm, panel consultation, or surveys. And we hope that the consultant can give recommendations in stage 1 on the methodology. Then can I ask the Law Society this question? What methodology do you prefer or suggest or propose? Law Society, which methodology for the review, please?
Traditionally, the methodology was a model firm, but the Law Society submitted 2 years ago now to the Judiciary a report which it had commissioned from KPMG Pete Marwick, which had statistics as to the sort of costs of the average firm relating to things such as salaries, rents and so on, which covered a reasonably broad range of firms from the sole practice right up to the very large firms. So that material is already available to the consultant and to the Judiciary and has been since we submitted the report in, Kenneth, 2013?
27 March 2013.
Yes, 2013, in 2013.
Chairman, no, in fact, such data are already available. I understand that, so you try to find an average or the mean. So why do you still need to hire a consultant? Is it that you don't have enough confidence in figures or data provided by the Law Society? Why do you have to spend money to hire a consultant? And a consultancy study will take some time. Chairman, we do respect the Law Society's views and the methodology that it proposes or prefers. But then this issue doesn't only affect the Law Society. Other stakeholders will also be affected. And so we think we should adopt a neutral and objective approach. And that's why we have decided to hire an independent consultant to assist us. But of course, our consultant will study the data provided by the Law Society, and the data provided by the society will definitely be helpful. The consultant will gather information on various fronts, and we also hope to obtain as much objective data as possible from various channels. Finally, this is not really a very complicated matter. How come this study can't be completed till the end of the year? And why is it that you can go to the Chief Justice only in early 2016? We'll try to do things as early as possible. We've just hired the consultant, and we will be able to complete stage 1 in the middle of this year. All right, I think we can conclude. Mr. Dennis Kwok, who raised this issue for discussion, is unable to take part in this discussion. But then he, as well as many members, want to have a clear timetable from you. I think we are all concerned about this issue of SHR. We hope that the report will be available as early as possible, and then now we hope to have a chance to discuss that report. So we thank the Law Society and the Judiciary Administration for coming to our meeting. This meeting will come to an end. Thank you very much.